Thank you for coming. It's always glad to see more people. So, and for anyone who hasn't seen this now, they can always, we're going to send out a copy, will be available. It's being recorded. And I can't see you, so if you do have any questions, please use the chat function at the bottom, ask whatever you want, and Allison Bird will be monitoring that to get to me. So there you go. All right, so the topic today relates to something that comes up many times, over and over again. So as we all know, divorce, more people are getting divorced. So a higher percent are not having kids. So there is an important question in the estate planning world about what do you do when you're a married couple or life partners, you're together for life, hopefully, and you either have kids by prior marriages or you have no kids at all. So there's no natural bounty where you both spouses, both life partners want the same thing at the second death. They may even say they want it, but the drive, the attachment, the blood attachment isn't quite the same when you have two life partners or two individuals in a married couple who have the same common children, and they both want to make sure their children are taken care of. You don't have that. You don't have that same significance to wanting exactly the same thing. And so the question becomes, what happens when the first spouse of that first person in the couple passes away? So before I get into the exact specifics, let's pull back just a little bit and go into what it is we're talking about. So 2-minute education here. What are we talking about? Talking about estate planning. What's estate planning? Right now, everyone controls, at least in the United States, everyone controls all their property matters, financial matters, healthcare matters. They control everything. Don't hurt anyone else. To break the law, you are free. But what if you can't do it? And there's two situations where you cannot do it: incapacity and death. There is a state law, court-based system to deal with all those things. Guardianships, conservatorships, administrators when you pass away. In some states, they're all called PRs or other names. But in Georgia, we have those various different names. There are court-appointed, court-oversighted individuals who will take over and manage your affairs, your health, or whatever the issue is, or estate, or whatever it is. It's a necessary evil. It's good to have if you have nothing else, but it's not pleasant. I can tell you now, it is not pleasant. However, state law allows us to essentially privatize almost that entire system. So what is that? That's estate planning. You're privatizing that court-based system. You can privatize almost the entire thing. So what does that end up meaning? A series of legal documents where you get to control who's going to be in charge and what's supposed to happen, at least in general anyway. And those documents include two, what I call agency documents, where you appoint a legal agent or a helper, a legal helper, to assist you while you're alive if you need assistance. In financial matters called the power of attorney. And in Georgia, this is different in different states. It's called, in Georgia, it's called an advanced directive for healthcare for body decisions. Deal with hospitals, insurance, medical insurance, health insurance companies, doctors, hospitals, HIPAA representative, all that stuff. No brainer. You should do those, but every 3 to 4 years, update them, and those are great to have. You then have the rest of what I call your core estate plan, a document that says, what happens to my stuff when I die? And that may be either a will or something called a revocable living trust. And if you have a revocable living trust, you still have a will, but it's just a small little will. We call it a pour-over will. Its purpose is just to take assets at the probate estate and transfer them after you die into the revocable trust. So the will is the main doc, or the revocable trust is the main doc, along with this little pour-over will. Now, inside that main document, you're answering two questions for a couple. Number one, what happens to the assets at the first of your deaths? Number two, what happens to those assets at the second of your deaths? We're not talking about what happens at the second death when it goes to the kids or whoever it's going to go to. The topic of this discussion is question number one. It is the elephant in the room when you have blended families and couples with kids of prior marriages and couples without kids. It is the elephant in the room. Why? At the first death, when your significant other survives you, there is a draw. The draw is, or the desire is, to make sure that your surviving spouse or loved one is taken care of, your life partner is taken care of. And then you also want to make sure at some point, now, later, whenever, that you take care of the others you want to take care of. In a blended family, it's kids of prior marriages. If you don't have kids, then it may be your particular relatives or your desired charities versus the other individuals, family members, and their charity. But basically, you have certain draw attachment to certain beneficiaries, and the other spouse or life partner has their draw to other ones. And you could say, or they could say, right now, oh, we love them all. They're all like our own kids, kids from prior marriages. And that may be. But the question is that going to stay that way indefinitely? Or could that change down the road? Because that same blood connection isn't there. So that's the issue. When the first spouse or life partner passes away, if they give all those assets to the surviving partner, spouse, life partner, they can't control anything from the grave. I mean, they're deceased, they're gone. And the other person would own everything, give it to them outright. They would own everything in their own name. So there is zero control over those assets. So what do? How do I make sure that I'm taking care of my loved one, my spouse, my life partner, but also making sure that my kids, whoever it is I want to benefit, is going to eventually get assets as well? And that is the key question. And we talk to people, which I do often, about this issue. They almost all, not always, 70% of the time don't get that nuance. And then about 30% of the time, oh yeah, I get it. I've already read your stuff. I've read someone else's stuff. I get it. I understand the issues. Now, that is the key issue. I can tell you from experience, of all the discussions I have in my practice, this is the most difficult discussion I have with potential clients by far, because I'm enlightening them to the reality that they cannot control things from the grave unless they do things now to try to control them later after they're gone. It will not happen by wish, by magic, that's the way it should be. That's not what happens. Now, let's go through what the options are. So what I tell clients is, we're going to go through it. It may not be that pleasant, but at least we have some options. So let's go through the options, and we'll go through what situation would you pick one option versus another. So number one, there's no question, this is the easy answer. There's no question about it. Because when people come in to talk to us, this is what they want almost all the time until I explain the issue. And the simple answer is, you just give the assets to the survivor, and the survivor says, both of y'all say, I love you. I'm going to make sure that your wishes are carried out. If we have 2 kids by prior marriages each, you're all going to get 1/4 each, or whatever it is the decision is at the second death. That's the goal. Hey, I'm taking care of my spouse, my life partner, because that's my primary desire. And then I trust that that individual will do what I want now. They will do it later when they pass away, and they won't go out of their way to mess that plan up. Now,
Richard,
yes.
We do have someone asking, would you be comfortable having these discussions separately with the spouses?
That's a great question. So when an individual comes in and we have the first discussion, the lawyer either represents one of the spouses or both. If you represent both, most of the time, you've got to have a decision about confidentiality. You're going to end up all being on the same page. And it may be you don't agree and you'll have to go somewhere else. But if it's not clear, or if one spouse has all the money and the other one doesn't, It might make a lot of sense for the moneyed spouse to come to the lawyer, and the other spouse just does what they're going to do with their own assets. But that's a big upfront question. Is the lawyer representing just the one spouse or both? You would not meet with them individually, normally, and represent both. It's either going to be one or both is normally the way it goes.
All right. Thanks for that question, Shilpa.
Okay. Any other questions you got out there, Allison?
Not right now.
Okay, great. All right. So what kind of person will go ahead and go with this simple option? And if you haven't read, you didn't have to read. We did a newsletter. I did a newsletter on this back in December. I did it. It's pretty good. But what kind of person will go with option number one? The easy answer. And that is, number one, they have absolute trust and faith in the other spouse to carry out their desires. Absolute. Under the situation, they have total confidence it will happen. Number two, or as an option number two, they heavily favor taking care of the surviving spouse or life partner, and you got to have an and. They do not believe sufficient assets exist to go with another option. Or they don't like the other options, or, and this happens, they don't care. They literally don't care. And this, I hear this from time to time. They're like, basically, I want to take care of each other. After that, I don't care. And that's more likely in a situation where they don't have their own kids. So there are other relatives or charities like, you know what, I don't really care. Just take care of my spouse. That's good enough for me. So those are the people that would go with option one after being educated. A lot of people go with option one without being educated, just don't know any better. But the simple option, you have to understand with eyes wide open what risk that has for your loved ones. Now, let's go to option two. And this is the one that I think that a lot of people will go with. And that basically says, I have mixed desires. I absolutely want to make sure that my spouse is not going to be destitute. They're going to be financially insecure after I go, financially secure. I also want to make sure my kids or whoever my other beneficiaries, they get something at some point. So how do I guarantee that? Well, one way you guarantee it under option two is you give them something up front. So when you die, let's say you're the first spouse to die or the first life partner to die, you give everyone you want to benefit assets at your death. Now you could favor one over the other. I could favor the spouse, I could favor the kids and give the other beneficiaries the rest. But I'm going to give everyone something. I'm going to try to make sure I guarantee financial security for the spouse. I mean, they have lots of their own assets already. And I want to make sure I give something to the kids or other beneficiaries. Now, the question becomes, are there enough assets to go around? Number two, how much do I want to give to the non-favored at the first death? So the favored at the first death may be the spouse, or it might be the kids. So how much do I want to give to the non-favored? So if I'm favoring the spouse, how much do I want to give to the kids or the other beneficiaries? If I'm favoring the kids, how much do I want to give to the spouse? And so that could be a small number. It could be really simple, a little specific request right off the top, and you can change your mind. If we use, as we talk about later, I favor using a revocable living trust as the main document. One of the benefits, there's multiple benefits of doing that in these cases. One of them is there's a specific bequest schedule. So you can easily change what you give to the non-favored, whichever it is, by a number. Just I give $100,000 or whatever the number is on that sheet of paper. It's easy to create and change. It's just a schedule attached to the revocable trust. The client can do it on their own. They don't need the lawyer to do it for them. Change it anytime they want. The other option for easy change for this kind of thing is via a beneficiary designation. And that's something else to consider. Assets don't all pass through your documents. Some of them will pass by beneficiary designation. If you have any joint assets or right of survivorship, you can control it that way. So there's other ways to get assets to the favored or non-favored outside this kind of master planning document. And you need to consider all that. But the key is, I'm going to give something to all these beneficiaries, be it large, small, medium, whatever the amount is. Then the theory is, for most of these people, you know what? I gave them something. And if they never get another dollar, you know what? I can live with that. I trust my spouse, my life partner, do the right thing and get them more later, or vice versa. But it's okay. If they never get another dollar, I can live with that, or I'll be deceased, but I can live with that. That will be okay. I will do good enough now and be done with it. So that's option number 2. And that's where a lot of people end up. And one of the reasons they end up there is it guarantees a result. And number 2, there will likely be no post-death disputes. There may be some disgruntled people that I don't really like what my deal was. What are they going to do about it? Now, another way to avoid a post-death dispute, talk about it later if we have time, is using the revocable living trust. You fund it, you put your assets into it, the ones you can, and the chances of having a post-death dispute in that situation are close to 0, based on how the whole system works. And if you have good documents to get that done. So by splitting everyone up at that first death, you are making it highly unlikely there will ever be a post-death dispute, even if someone's not happy. And you are sure that everyone got some money, everyone got some assets, and that you feel good enough about it. So that's option number 2. Now let's go with option number 3, the final option. Under option number 3, what we're saying is either option 1 or 2, we're giving everything to that spouse or life partner, or we're giving part to the spouse or life partner. However you give it, you end up giving at least some of those assets in trust. And that would be a little sub-trust. You can call it credit shelter, marital, or marital. There's all different kinds of little sub-trusts. But you're giving it to, so let me back up. The primary estate planning document is either a will or revocable living trust. Inside that main document, which I believe with a blended family situation, most of the time, even with you have no kids, I believe 90% of the time, the right answer is probably going to be a revocable trust for multiple reasons. Now, let's say you go through a revocable trust, or whichever it is. Inside that main document, there will be a little sub-trust. So there's a little decision tree inside that main document. It says, hey, while I'm alive, take care of me, at least with the revocable trust. With the will, it only deals with death. Then it says, upon my incapacity, a backup trustee takes over and takes care of me, primarily, maybe my spouse secondarily. Then it says, upon my death, what happens? To the extent the assets go to the surviving spouse or the surviving life partner, it would go in a little sub-trust or trusts, 1 or more trusts, depending on tax implications. That spouse could either be their own trustee of their own trust share, or a third party could do it. And there's ramifications from doing it that way. But the purpose of passing the assets in the little sub-trust, to give it to them outright, they can do whatever they want with it. There's no guarantee of anything. To give it to them in a trust, there's some level of guarantee. You're increasing the odds that the original plan of the first spouse to die, those desires, will be carried out at the second death. Why? Because the little sub-trust for the spouse or life partner says that's what happens. It says, take care of my spouse or life partner, whatever it is. And then at their death, the remainder comes back to the first spouse's family. It's already in the documents. It says what happens. Now, let's go to where that could go south. Number 1, who's the trustee? If the surviving spouse or life partner is the trustee, there's so much flexibility in these documents that they could take advantage of the terms and get either all of it or a lot of it out of the trust before they die. And if they do that, they control all the assets they've removed. So they could indirectly kind of gut out your plan and make it not work. Which means that you would probably, if you want to really lock in a guarantee, then you need a third-party trustee. And because of the dynamics of who's involved most of the time, and my next newsletter is going to be on choice of fiduciary, who should be in charge of different functions. in these kind of situations, the majority view is going to be, if you're not going to use the spouse or life partner as their own trustee, you want a third party, basically a professional, normally a trust company. The reason is that there could be fighting going on, disgruntled people going on. When you have other individuals, they start fighting. You have a trust company with the power to move and replace. If they don't like the trust company, they can move it, he or she can move to another trust company, but it's always with a trust company. They have certain rules they're going to live by, and that's the deal. So it has to be reasonable and prudent under circumstances. And so they can fight all they want, but there's nothing they can do about it. They'll be fighting with the next one. So if they're reasonable, everything is fine. If they're not reasonable, they're not going to be just going to be unhappy, and that's life. So option 3, instead of giving the amount you give under option 1, all of it, under option 2, part of it to that surviving spouse or surviving life partner, you don't give all of it outright or all of the partial amount, depending on what the assets are, outright. You give at least part of that in a little subtrust, and then so you control what happens in the second death. And then to solidify it, you would make a third-party trustee if you're okay doing that. Now, I have clients that will say, I can go as far as the trust for my spouse. It's a bridge too far to put in a third-party trustee. I don't want to do that. And that's fine. All I care about is eyes are wide open. Client makes a decision based on knowledge about, they know the pros and cons. It's not my life. It's not my family. I want to make sure the individuals understand what their options are and they get to choose. All right. So that is option 3. Now, who's doing what to who? So I would say that the majority of people, I wouldn't say that. They're all over the place. I have clients that are all over the place. I have some that say, I trust, especially if there's no kids, they're more likely to go with option number 1. You know what? I trust them. I don't care that much about what happens after both of us go. That's fine. If they have kids by prior marriage, it's fact dependent. They may seriously trust that spouse, but they don't trust anyone that much. Doesn't matter who it is, no matter, because of all the things that could happen in the future. And I can tell you right now, it happens. There's some things that people care about that I don't think ever happen that often. Like people care about simultaneous death. I've been doing this since 1987. I've never seen it other than read about newspaper or on TV. I've never seen it, but this does happen. To the extent the surviving spouse has power over the assets, either because they are getting it outright or they're the sole trustee with incredible flexibility. I'm just telling you, I have seen it. Every lawyer has seen it. The spouse will say, aha, now I can do what I want. I've literally had someone come to me. I'm not sure if the body was buried yet. It was with less than a week. It was less than a week. They came in and wanted to change the whole plan, which made my gut turn over. So I just want everyone to be, who's either advising or dealing with on their own, to understand the risk exists. It doesn't mean things are going to go south. It means a risk exists. And are you okay with the risk? If you're not okay with the risk, then there's other ways to deal with it. You got to deal with these trusts or the like. So now let's go to some side issues that will help kind of make this decision a little bit easier for you. Hang on 1 second here. Now, to the extent under option 3 that we would pass assets to the spouse, there are certain assets. I kept saying partial sum of the assets. You normally do not pass all the assets in trust, that's the extent you're giving it to the spouse, because 3 particular assets we normally, not always, but normally will go outright. And they include 1, the primary residence, and that's for income tax purposes. Because if the spouse gets the residence outright and they sell it within 2 years, they're still considered married for this purpose. Up to $500,000 of gain is just wiped out. If it's more than 2 years after the first spouse died and they own it, to get this benefit of the gain wipeout, the surviving spouse needs to own it and it is their primary residence. They sell within 2 years, up to $500,000 of gain is wiped out. They sell it after 2 years, even a day, they're considered single, up to $250,000 of gain is wiped out. If you put it in this little sub-trust for the spouse, they don't own it for this purpose, and therefore you don't get the gain wipe out. So there could be a capital gain on the sale of a primary residence. That's number one. Number two, IRAs, qualified plans. Basically, tax-deferred savings. Tax-deferred savings have a bunch of funky rules about them. If they're married, not life partners, but if they're married, the surviving spouse gets way better rules than any other beneficiary. They can roll over a 401k IRA into their own IRA account. They don't have to take anything out until they hit the required beginning date, which I believe is around March, can't remember the exact date, March 1st, something like that, don't quote me, of the year after they turn a certain age. It used to be 7.5, then it went to 72, and now it's 73, going up to 75 over the next bunch of years based on a change in these laws that are constantly changing. So about 74, at 59.5, you can have whatever you want. Before 59.5, there's limits, but the spouse gets it. They can take out, effectively, we can work it out, take out as much as they want, especially at age 59.5. But they're only required to take out the minimum beginning when they're about 74, at least today. Why does that matter? The longer the assets stay in the IRA qualified plan, the more tax deferral you get. You pay less tax. Less tax is a good thing. So if you pass it in trust, when it's sub-trusts for the spouse, that's not what happens. They do have the ability to defer until the first spouse to die would have hit that required beginning date age. But they take it out over, I didn't tell you this part. When they start taking it out, if the spouse rolls it over, they take it out with beginning of the required beginning date over the joint life expectancy of someone their age and someone 10 years younger. With a spouse, and they don't roll it over, they're the beneficiary of the decedent's IRA, their surviving spouse. They take it over a single life expectancy, beginning on their required beginning date. So no matter how you slice it, in all, not all, but almost all situations, it's going to be way better to have the IRA's qualified plans pass outright to the spouse. Now, the exception is I care way more about who's going to benefit and how they're going to benefit than the taxes. And in that case, you pass the IRA's qualified plans into trust for the spousal beneficiary, and we just live with the tax consequences. It's not as good, but that's life. So there you go. The third, so it's the home, IRA's qualified plans, and the tangible personal property. So to the extent you want to give the furniture and the clothes, the TVs, computers, and jewelry, whatever, to the spouse, we know we don't put that in trust. We don't just give that out. And if you want to give that to the kids or whoever else at your death, everyone's probably going to be fine with, not everyone, most people will be fine with it, especially if you're clear about what you want to do. So those would go outright, and then the rest that you're giving to that spouse or life partner would go in trust. It's just an aside. And then some, let's see, one big caveat, and we'll go over a couple other side issues. One big caveat is if you go in trust for spouse, I kind of inferred this before. If you go at least partially in trust for spouse, that increases the odds of a post-death dispute, especially if the spouse, primarily, especially if the spouse is the trustee. If the spouse is the trustee, then the spouse and the children, by the prior marriage or whoever's getting it, they affect each other. So the investments the spouse makes, the distributions the spouse makes, they literally affect what these children, the beneficiaries, are going to get and when and how they're going to get the whole thing. It's going to affect what happens to them later. And so there may be a desire for getting lots of information and questioning what the surviving spouse is doing. And this could lead to butting heads and some real family dysfunction. So I throw that out there. It is viable, but that would push, if you don't mind doing it, a lot of people don't like doing it, but if you don't mind doing it, putting it in a trust company, and that should pretty much get rid of the fight. Why? The trust company has to act in a reasonable and prudent manner. It is what it is. This is the deal. Kids, bug off. You'll get it when you get it. And they're going to get assets. Why? Because it's the trustee's job to make sure they get it. So that is an issue. The risk of post-death dysfunction and disputes if the surviving spouse or life partner is their own trustee of their own trust. Number two, this came up with a client matter not too long back. You can only control the assets that you own. In a state like California, community property state, you control, everyone owns half. The spouses don't have. Everyone owns half. It doesn't matter what title says. It doesn't matter if it's 100% in one name, 0 in the other. It's 50-50. I think it's crazy. It is what it is. In a common law property state like Georgia, which I understand, title matters. I mean, title says you own something 80-20. Guess what? You own it 80-20. If it's 50-50, it's 50-50. It's 100% 0, 100% 0. It is what it is. So when the spouses come in to do this planning, let's say one of the spouses, they have 2 kids each, or 1 kid each, or whatever, from prior marriages. But one spouse has most of the assets. Well, guess what? That spouse controls the assets in their name. The spouse without much assets cannot control the other spouse's assets. They can only control their own assets. And you may say, well, that's pretty obvious. That's not always so obvious to people. So you can only control what you own. And then you control it via how you pass it. You pass it outright, you give up the control. If you pass it in trust, you retain some control. And if you have a third-party trustee, you absolutely retain control. So it's all different levels of that. What if under option 2, which is where a lot of people end up, I'm going to give something to each side. Something to my spouse or life partner. I'm going to give something to my kids by a prior marriage or other beneficiaries. The issue, the elephant in the room on that one is, are there enough assets to go around? Because I can tell you the surviving spouse, unless they have their own significant wealth, are going to be uptight. They're going to say, wait a second, we're living on these assets now. I'm going to need these assets when you go. I'll make sure the kids get the assets. But then the other spouse is like, wait a second, how do I know for sure? There's no guarantee you're going to get to my kids. And they're frustrated. Everyone's frustrated. So one way to deal with that is to try to create more wealth. We say, well, that's a no-brainer. But there's another way to do it. If you're healthy and basically you're insurable, you're not too old and you're relatively healthy, you can buy life insurance. It may not be pleasant to buy life insurance, but it could be I'm not a salesman, but it could be a reasonable cost to pay to solve this problem. Because I can tell you, this is a difficult issue for a lot of people. And if you create this additional wealth, like, okay, well, I'm going to give the insurance either to the spouse, or I'm going to give the insurance to my kids. So they're going to get this and they're going to get this. And it's all good. Life is good. I can stop thinking about it. So that is something about creating more wealth might resolve that problem. And then lastly, we only have 5 minutes to go here, I believe. Another thought, and that is, so that's question number 1, how to pass assets at death. If you're in this situation, do you pass it outright with no control? Do you pass it in trust? Who's the trustee? Do you give everybody a little something and just be done with it? How are we going to do this? No matter what you pick in this situation, you are going to, I would recommend for you, using a revocable living trust as your main document rather than a will as your main document. Why? Number 1, it is the absolute best way outside of or in addition to, either in lieu of or in addition to, a prenuptial agreement to ensure that your desires are carried out as you intend. There's lots of reasons for that, but it will basically prevent a post-death dispute in most situations. In our practice, we've never had any. If I can see it coming, we're going to recommend a revocable living trust. And when you have a blended family or other beneficiaries desire a second death, that is an open season for people to be disgruntled. And so we want to avoid people who are disgruntled from ever being able to do anything about it. It is almost impossible to break a revocable living trust. And in the way you draft it with an interim clause and all kind of stuff, basically the disgruntled party, outside of a fraud or criminal action, kind of wacky, really wacky stuff, they're never going to hire a lawyer. They're going to have a hard time even finding a lawyer who'll take the case. I don't think they will. It'll be rare they can find a lawyer to take the case. It won't happen. You have a question, Allison?
There's no question on the screen, but an issue occurred to me that I know a lot of people, I've gotten a lot of questions from clients about, especially after the changes in the trust laws that happened in Georgia a few years ago that do make it a little bit easier to change an irrevocable trust. And of course, people's revocable living trusts become irrevocable when they die.
Right.
And they always want to know, well, what does that mean exactly? How could it possibly be changed, especially under these new laws? Can you address that a little bit?
Yes, that's a great question, Allison. We did not talk about that beforehand. That's a good question. All right. When you have a revocable trust, you change anytime you want. But what if it's irrevocable? Either because you did a gift, an irrevocable gift, a tax type gift while you're alive, or at your death, let's say you give in trust to the surviving spouse or the kids or wherever it's going. But you're deceased, so the person has the power to amend is deceased. There's no more power to amend. It's irrevocable, cannot be revoked, terminated, that kind of thing. Before July 1, 2018, it was very difficult to change the terms of those trusts. You needed the flexibility to modify in the terms of the trust. You couldn't come in from the outside and change the terms. You had to do it from the inside, whatever terms that were already there. But what if we didn't have good terms that allow us to do what we wanted to do? In July 1, 2018, Georgia, on a trend in the country, created a series of provisions, 3 of them, that enable the potential ability to modify modify or amend an otherwise irrevocable trust, which doesn't sound like it makes any sense, but it is. The court already had some power to do it, and we expanded on the power of a court to modify. Number 2, we had the ability to do what's called decanting. Based on the power to distribute assets out, you could distribute in lesser manner out, which means instead of giving it outright out, you give it in further trust. So effectively, they call it decanting. It's kind of like a wine decanter. You're taking a bottle and you're pouring the wine out from theoretically one wine bottle trust into a second wine bottle trust, leaving the sediment, the stuff you don't want, in the first bottle and only putting in the good stuff in the new bottle. Effectively, taking the assets out of trust 1, creating a brand new trust 2, and creating trust indirectly modifying the terms in that manner. Of course, there's rules about all this stuff. The third way was to have a non-judicial settlement agreement. And a non-judicial settlement agreement says if the same parties that would have had to consent or get notice or whatever to one of these other 2 options, if they all agree, then they can do it without a court having to do anything. So if a court can do it, they can do it. With the same people involved, they can do it privately. So there's lots of rules about who's got to get notice, who's got to consent, a bunch of stuff. But those options now exist. Now, let's go back to where I think you were going, Allison, which is, wait a second, I set this trust up to make sure my kid's in good shape, and then can my spouse change it so they're not getting it? And the answer is, you're not going to be able to use these other methods to hurt a beneficiary. You can't hurt them. You can't take rights away from them unless they consent to it.
So they have to be the same beneficiaries, right? Between
the same
old trust and the new trust.
There is an indirect way to add beneficiaries. Something, a lot of estate planning stuff, things you cannot do directly, you can do indirectly. You can add it, this is a little technical, but you can add in a limited power of appointment, the power in someone to modify, including a broader class of beneficiaries. They can then exercise it to bring more beneficiaries in indirectly.
But they can't reduce the beneficiary. They can't kick someone out.
Reduce a beneficiary's rights. That would be a problem. Now, they could in one situation, and that is in the terms of the document, you give that person a limited power to modify, limited power of appointment, the power to modify. And if you say, hey, I trust my surviving spouse or life partner to modify how the assets pass down to my kids or among all these kids or whatever, you're giving them power to do it, which means you better be aware they could exercise it and no one can stop them. Because those powers are non-fiduciary in nature. There is no like standard. You're just saying whatever their beliefs are, they can do it. So that's that. Thank you, Allison. It's a good question.
Well, and we have a few more questions that popped up in the meantime.
Okay.
We have one from Larry and then another one from Shilpa and Marilyn. I'll get to those. But Larry wants to know, what about second marriages? Which carries more weight, a will language or the prenup language?
So they do two things. That's a great question. The prenup deals with rights. What rights do you have? The estate planning documents decide what happens, who's in control, and what happens with those rights. So the prenup could limit your rights to property, but whatever rights you end up with, those provisions will deal with them. Now, so for example, prenups can do two things. Number one, control who owns what in a divorce. So what's part of the marital estate? Child support, you pretty much have to go by state law, and alimony rights. So if you got a divorce, who gets what rights? But it can also say at death, what happens? So for example, it might say, well, the home, the primary residence, and these kind of assets must go to the surviving spouse. But that's just an example. And then it's a restriction on your rights. You have no choice. If you don't do it in your will or revocable trust, the surviving spouse can enforce a contract right under the prenup. So basically, it creates or modifies rights, and then your estate planning documents, your wills, your revocable trust, and the like, deal with whatever rights you have.
All right. And then Shilpa also wants to know, why not think of testamentary trust for the children from a prior spouse?
I'm sorry, can you repeat that question?
She says, why not think of testamentary trust for children from a prior spouse? I guess maybe she's asking, instead of setting up a revocable living trust, just do it as testamentary trusts.
Testamentary means at death. So it wouldn't be a lifetime gift, assuming I got the language right here. So there were three questions you answer when structuring documents with a married couple or life partners. Number one, how do assets pass to the first death? Number two, how do assets pass to the second death? And number three, where are the answers located? What's the primary estate planning document, a will or revocable living trust? That is question kind of number two, kinda. So question number two is, at the second death, how do the assets pass down to the kids or other loved ones? Testamentary trusts. Now, so that's a whole nother discussion. But let's go back to question number one. Option number two. So option number two, and this was a little hole in what I said, so this might be what we're talking about. So I had said under option number one or two, to the extent you give to the spouse, at least part of it goes in little subtrust. That aside, now let's go to, I said under number two, you give part to the spouse and part to the kids or other beneficiaries. I just assumed it was outright. It doesn't have to be outright. It can go in testamentary trusts. So the same way that you would pass it to them at the second death, so if that was the second spouse to die, the spouse didn't survive them, and they gave it down to the kids in trust, you could do the same thing at the first death. Now, the question becomes, are you giving them enough to make passing it in trust worthwhile? If you're giving them, $10,000, $50,000, $100,000 each, you may not want to put it in trust because the administration costs of the trust aren't usually worth a small trust like that. There's other ways to do it. If you're giving them something significant, yeah, you basically would have the same trust that would exist at the second death pop up to be able to be used at the first death. And it would control the assets you give at the first death. I hope that helps.
All right. And then the only other question right now is from Marilyn Heck. What trust company are you currently recommending to act as trustee? And I know we typically give people choices and it may depend on the type of plan they have,
Yes.
right? What,
So I'll go over in general how you think through that question. So to me, there are two general types of trust companies. There is the old school full service. It's 90-something% of all trust companies. They do everything. And the key to everything means they also do the investments. They are the ones investing the assets in-house. The second type of trust company, which is newer, the first in Georgia was Cumberland Trust, and then another one was an offshoot of that, and another one called Pendleton Square Trust. There are others out of the state. Those are from Tennessee, but they have offices in Georgia, and those are the ones that we use in Georgia. So those trust companies do not invest assets. They are referred to as, I call them specialized, some people call them directed. There's a reason they call it directed trust, due to this legislation on directed trust and who's liable and how they liable and stuff like that. But so if you want to go with a specialized, where you want your investment advisor, or you have specialized assets and you want someone else to manage those assets for you, you would go with the specialized one. Not always, but most of the time. If you want a full service, hey, I want to push it over there, I want them to do everything, then you go with the standard old school trust companies. Now, I would say I would categorize these old school trust companies in a few different ways. One, you do have old school big bank trust companies, big institutions. You then have what I would call very high end kind of family office type things for the ultra wealthy that are very high touch, high service for wealthy individuals with very high minimum amounts. And then you have what I call the boutique, high touch, high service, smaller trust companies. An example of that is Diversified Trust, Southeastern Trust Company. There's others. But that's a kind of a smaller boutique, high touch, high service, and they do everything. At least they can do everything. So I hope that helps. And normally what we do is we go through with the client and or we set you up, and then you can go talk to, we know people in all these trust companies, you talk to them and see who you like, who you have a better rapport with, and you like the way they do their stuff. And from a cost perspective, the full service is going to be charging, in effect, two fees in one: the investment advisor fee plus the administration type fee, do everything else, the fiduciary fees. And that's usually between 1.1 and 1.6%, most between 1.2 and 1.4% a year, about. Whereas a specialized, they say starts about, let's say it starts at 0.6%. I would say most of our clients are about 0.5, but about 0.6 of 1% down. And as the amount of assets go up, the percent comes down. So there you go.
all right. Thanks, Richard. And it's about 10 till the hour. Are we going till 1 or 1:30 on this?
I think it was 1, I think was the latest, or we could shut it down if we have no more questions.
Okay, right now we don't, well, let's see. Yes, Katrina has a question. Did you say that there's no step up on real property that passes via an RLT at the passing of the first spouse?
I did not. So I did not even mention step up in basis. Let's go over that. So so here's the general rule. There's some stuff out there about people trying to take a position it's not the case on the very technical reading of the law. But in general, assets subject to the estate tax system when you die are subject to the estate tax, whether you pay a tax or not, the estate tax, death tax. But any assets, with one exception, that are subject to the estate tax, change basis, your investment in the asset, change basis to date of death value. That's usually referred to as step up in income tax basis. That means if there's kind of built-in gain, you bought Home Depot stock at $60 a long time ago, it's now worth $300, you die, the basis gets jacked up to $300. If you sold the asset on date of death, there would be zero gain or loss. But it would also mean if that Home Depot stock, you end up buying at a high of $450, it's now worth $300 when you die, it goes down $300. You lose basis. It just readjusts so that all assets that if you sold them would create a capital gain or capital loss while you're alive. All of those assets, the basis readjusts to date of death value, no gain or loss. The exceptions, IRAs, qualified plans, and other what's called IRD, income respective decedent, which is basically ordinary income that has never been taxed. That does not get step up. That just stays the same. Now, the question becomes, wait a second, I put it into a revocable trust. I didn't own it. That doesn't matter. There's other tax provisions that say if you give something away and you benefit from it or can terminate it, get it back, whatever, there's some issues in other states, but not Georgia. If that's the case, I have control over what I gave away. I can benefit from it. It never went away for tax purposes. It was an incomplete gift and therefore comes back into the state tax system when you die. So it doesn't matter if you own it in your own name. It doesn't matter if it's in a revocable trust. It's includable in the estate tax system when you die and therefore gets this step up or change in basis.
All right. We don't have any other questions right now.
Okay. So this was, I can't see you. Hopefully you liked it. The goal is to do effectively a lunch and learn right now by webinar about once a quarter. The goal is for next quarter, a huge topic. Thank you, Trina, for a little thank you. I never saw it before. Thank you. It's a little clap. Thank you very much. Next quarter is going to be dealing with IRAs and qualified plan beneficiary designations under what's called the Secure Act. It's now Secure Act 2 and a whole bunch of changes. And effectively, the topic really isn't about giving something outright. That's simple. The topic really is about passing those assets in trust. And normally, not always, because with a spouse, it isn't as good, and most of the time we don't do it. When you go to the kids, if you go to the kids in trust, especially long-term trust or dynasty trust, which we're huge advocates of, it's a huge benefit over just keeping it simple. The rules are wacky. So the IRS has changed these rules multiple times, government's changed it multiple times. So what we're going to go over is now, where are we? Where are we now? What are the options? There's pros and cons to each option, and I'll go through that in our next quarterly. That's the goal for the next quarterly webinar. Thank you very much. If you have any particular questions about your own self, about yourselves, you can email us, or you always, of course, come in. Their initial meeting with us is always no charge, or not almost always no charge. We'll be happy to talk to you about your situation, see what we can do for you. All right. Thank you very much. Enjoy the rest of your day, and thanks for participating.